Hey, it's Joe. I'm here with Gavin Bogle, and you have your own intellectual property firm.
Right. I'm a partner in a small firm.
Named?
Magyar and Bogle.
URL?
PC. Oh, magyarandbogle.com.
Okay, fair enough. There's a free plug. You spoke today at PEDS 2040, and you said something that really caught my attention. And you said, at this point, diagnostics are really not patentable.
Right.
What did you mean?
Well, under a recent case, the Mayo Clinic versus Prometheus, the Supreme Court of the United States said that the diagnostics at issue in that case are basically an application of natural phenomenon, or the use of a natural phenomenon, and therefore not patentable. And it just does not constitute patentable subject matter. And in that case, it was actually the use of diagnostic to alter the treatment regime that a doctor would use, and they found in that case that that was not patentable. So where we are today, I think, is pretty clear that I have a very hard time picturing the in vitro diagnostic that would actually be patentable. I'm always open to innovative people coming up with novel, innovative solutions, but if you're measuring an analyte that occurs in the person, even as a result of a disease, and comparing it to its normal state, that's a natural phenomenon and not patentable. The lower courts all have to follow that. And I think this is it's not actually that new. It's a couple of years now, and the inability to patent anything that's a natural phenomenon, or basically uses a natural phenomenon without a significant transformation of that natural phenomenon. And I am simplifying here, you have to understand, but anything that doesn't provide a significant transformation of that natural phenomenon, other than applying intellectual thought to it, is not patentable. That's basically what the case is.
So let me take it to an easy extreme. I have a blood pressure cuff. I'm measuring someone's vitals.
Right.
Not patentable?
Well, the cuff itself might be. The machine that you have might be, but the test of relating the pressure to some disease wouldn't be. So I think about in vitro diagnostics, where you're measuring what has been tried to be. A lot of diagnostics you discover the relationship between an analyte and a disease, and that relationship is not patentable, even if it's new and novel and unobvious.
Have you, since Prometheus, seen a shift in the amount of investor or entrepreneur energy in diagnostic innovation?
I'm not sure. You know, I don't have a good sense of overall. I think that if there hasn't been, there certainly will be a shift, no question. And the Prometheus case was, a great example where Mayo wanted to use the diagnostic, and Prometheus wanted to sell the diagnostic and have the differentiation between a buyer and a seller. And the buyer wants it to be cheap, and the seller wants it to be proprietary. So.
And for those of us who don't know, what did Prometheus end up doing as a result of this loss?
Well, it's still a company that goes on. They have lots of diagnostic tests, and they most places, at the end of the day, most hospitals and most purchasers want to buy the test rather than make it themselves. And so, for that matter, there's always going to be a marketplace, and it's going to be the end result is the market is going to, and marketing is going to lead to sales.
And I recall you having said that at this point, marketing is a better defense than a patent in the diagnostic space.
Except for the example that you used, where you actually have a machine that you build and if it's a new and novel and unobvious machine that does something that nobody else does, I can imagine lots of ways of patenting that machine. It's the intellectual input that's not patentable.
Very interesting.
Some would say that the intellectual input is actually the real heart of these inventions, but the patent law is going the other way.
Gavin Bogle, thank you very much.
Thanks.